Welcome, everyone. What we are going, well, tonight's webinar is the estate planning, wills, and trust. And what we will learn tonight is how to avoid the most common estate planning pitfalls. Now, even the best of us with good intentions can make mistakes. There was a financial advisor named Ron who got married, had children with his first wife. He later got divorced, remarried, and had more children with his second wife. And he wrestled with the decision as to how to divide his assets and also his business. Now, some of Ron's children worked in the business, some did not. Uh, Ron was finally able to get a will written. However, a few years later, after being married to the second wife, Ron decided that he needed to redo that will. So he went and met with a couple of attorneys. Unfortunately, during the process, he died in a car accident. Now, at the end of the day, no one could find the original will. The second will was never executed. Ron failed to prepare for his estate and for his children and his wives. All of the interested parties lawyered up, and legal bills racked up to the tune of over $1 million. And it took 4 years to settle the estate. Now, this is a nightmare that could have been avoided. What we'll discuss tonight again is to avoid the common mistakes, the elements and the components of a good estate plan, and also steps that you can take to get started now. My name is Michael Owens. I am the president of Carolina Financial Services Group. I've been an advisor for 30 years now, so that means I've been around the block several times. Before we get started, well, let me do this too, just to make sure. If you can hear me and see my screen, please type yes into the chat box or into the Q&A box. So if you can hear me and see my screen, please type yes into the chat box or the Q&A box. Okay, good. Okay, to get the most out of this webinar tonight, what I would ask you to do is to please turn off your cell phone, click out of any other windows that may be open on your computer. If you're in a room, close the door and focus. Please ask me questions in the chat box or the Q&A box. We typically save questions until the end, and the workshop will probably answer most of your questions. Now, one more thing, do me a favor, grab a pen and a pad to take notes. During the workshop tonight, I will suggest that you write some things down, and then it will also be good for you after the webinar to be able to go back and review your notes. Now, we've got a special offer tonight. As part of the webinar, you are eligible for a special offer. And if you stay until the end, the webinar will last roughly about 40 minutes, maybe 45 minutes. As part of our offer, we will go through the process of educating you on what you need, what decisions you'll have to make along the way, and approximately how much it will cost. Now, attorneys love our process because we've reduced the number of hours that the attorney has to do in reviewing your documents and doing the legal work. It is for these reasons that most people who watch this estate planning webinar take us up on our offer. So let me show you what that looks like. So you should see a slide out now on your screen. If you look at the green button, you can click on that green button which says schedule a call. It will take you to a page that looks just like this one. Each blue dot is a date. You get to pick a day that works best for you. Now, I'll show you the second page of this in just a few minutes. Let me get rid of that. Estate planning is defined as the accumulation, the preservation, and the ultimate distribution of assets. Most people think of estate planning as the distribution of assets, but it really involves all three. So I would write that down. Estate planning is defined as the accumulation, the preservation, and the ultimate distribution of assets. Now, many investment advisors will focus only on the accumulation stage. However, since we specialize in working with those who are retired or getting ready to retire, we will focus on the last two. Tangible reasons for good estate planning: avoid unnecessary legal costs, avoid additional or unnecessary tax loss, and the possible protection against Medicaid and the spend down. Now, 2 out of the 3 people who are watching this tonight will probably need some type of nursing care at some point in their life. You don't need to tell me that the costs are extremely high, just like the premiums for long-term care insurance are high. That's why protecting against Medicaid and the Medicaid spend down is truly one of the major reasons to make sure that your estate gets buttoned up. The number one risk that retirees must take off the table is longevity, because longevity is the multiplier of all other risk. I'd write that down. The number one risk retirees must take off the table is longevity risk, because it is the multiplier of all the other risk. Now, my motivation is personal, and that has to do with my grandparents. Both had to have stay-at-home care in the last few years of their lives. They were both raised on a farm. My grandmother's name was Annie. She was a teacher and principal before she got married. My grandfather's name was Mark. He was a farmer. My grandfather was diagnosed with Parkinson's disease at the age of 70. This disease took control of his lifestyle. It forced him to depend on others to help him get dressed, to help him eat, and to even get out of bed. My grandmother had to hire a caregiver to help her care for him. Now, he died at the age of 79. At the age of 93, Annie, my grandmother, needed stay-at-home care as well. She died on Christmas Eve at the age of 95. Her stay-at-home care cost $36,000 a year. Now, this was over 35 years ago. Today's cost of stay-at-home care starts at $55,000 a year. $55,000 a year. How much do you think this type of care will cost in 10 to 15 years when you may need that care? If you care to go into the chat box and just give me your idea as to how much this care will cost in 10 to 15 years. You can place that either into the chat box or the Q&A box. If you think that long-term care insurance is too expensive, think about not having it and having to pay $50,000 to $100,000 a year for stay-at-home care, assisted living care, or a nursing care facility. You need to be prepared for the what-ifs and not surprised by them. I'd write that down. You need to be prepared for the what-ifs and not be surprised by them. The two things that are avoidable or unavoidable in life are death and taxes. I'm sure you've heard that lots of times. And when you die, they both come at the same time. Now, the 2022 estate tax exemption is up to $12 million for a single person and up to $24 for a couple. Now, federally speaking, most of you watching this webinar may not have a net worth of 12 million or 24 million. However, even if your net worth is 300,000 or less, you still have some very good reasons to make sure that your estate plan is in order. Real reasons for good estate planning. Relieve loved ones from making tough emotional decisions. Bill, who had 3 children and decided that he was going to list his oldest daughter as the beneficiary of all of his IRAs, he told his daughter that he would like her to give a third to one of her siblings and a third to the other at his death. And Bill died, and his oldest daughter really struggled to figure out how much of the tax she had to pay and how much she would have to deduct from her siblings' shares. She stressed and agonized over that decision for a long time, primarily because she was in a higher tax bracket than her 2 siblings. At the same time, her siblings wondered why they weren't getting a third of the gross amount, not realizing that taxes had to be paid before their sister could make the distributions. This all could have been avoided if Bill would have decided to put all 3 children as beneficiaries. Everything would have worked out fine. He could have avoided this problem. Avoid or at least reduce family tensions and potential infighting. I had a client, her name was Mary, and she had a reasonable amount of money when she died. She made sure that her wishes were spelled out clearly in terms of how the money should be split between her 4 children. Now, you would think that there would be no problems with following these instructions. However, it gets a bit complicated. 3 of Mary's children were girls. And what she didn't do was explicitly spell out how she'd like her jewelry divided up between them. Now, remember, diamonds are a girl's best friend. As a result, Mary's 3 daughters ended up fighting and arguing about who gets what. When they finally decided how to split it up, at least 2 of them still had held grudges because they thought that they didn't get what their mother wanted them to get. Now, to me, this is a clear example of how a well thought out estate plan can help your loved ones avoid tough emotional decisions, reduce family tensions, and potentially infighting during what is already a difficult time. Another good reason for good estate planning is to avoid additional emotional trauma. I had a client named Tom, and he died without a will. Tom wanted all of his assets to go to his son and his daughter equally, but his son was married to an attorney. She insisted that since there was no will, that Tom's son hire an attorney. So Tom's daughter had to hire an attorney too. Now, the attorney told her that her brother wanted a certain amount of money, certain assets, and would not settle for anything less. Meanwhile, Tom's son attorney heard from his sister's attorney, who said that she wanted certain things and wouldn't settle for less. So do you see how messy this gets? As a result, Tom's son and his daughter did not talk to each other for 2 years. 2 years. One day, the daughter finally decided to go see her brother. And luckily, the brother's wife, the attorney, was not at home that day. So Tom opens the door, and his sister says, I don't understand why you're asking me for all the XYZ stock and all the ABC bonds. And the brother said, I don't want all that. Why are you asking me for all of these other things? You see, it was their attorneys using negotiation tactics. That's why they were not able to get a straight answer from each other. Now, once they came to that realization, the estate was settled in 45 days. If you would like to know how to avoid mistakes like this with your family, take us up on our offer. The real reason for good estate planning is to allow loved ones to transition through their loss more easily. It is to allow loved ones to transition their loss more easily. I mentioned to you earlier that I would come back and show you the second page of this offer. So let me go back and do that. So you go to the first page, you'll click on the blue button. It looks just like what you're seeing now, the second page. But after you've clicked on the blue button for the date, from the right-hand side are the time slots. You get to click a time that works best for you. Tools of a good estate plan, wills and trust. Wills and trust. In some states, you can have a handwritten or a self-written will, but in reality, it's not like another contract or legal contract where if you make an error, you can testify in court that you made a mistake and that that was not your real intention. Now, in this case, by the time your will is being reviewed in probate court, you're no longer able to step up and speak for yourself if you've made a mistake. That is why I strongly believe that you must go to a qualified attorney and get this done. That way, if there's an error in the will, the attorney can go to the court to testify and can tell the judge what your actual intentions are. By having a professional to do this, it significantly decreases the chance that such an error will occur. This is not a do-it-yourself project. Please don't try to do it alone. And I would write that down. This is not a do-it-yourself project. Don't try to do it alone. Current and accurate beneficiary designations. Current and accurate beneficiary designations. One of the big benefits that most people watching this webinar find is by taking our offer, none of us are attorneys. So, we're not going to try to upsell you on a certain type of trust or other items that you may or may not need. What we will do is we're going to help you make an educated decision based upon your personal goals, whether you should have a will or a trust. We'll also help you make sure that you've listed your desired beneficiaries correctly on all of your financial accounts. I've seen situations where people have gotten divorced and remarried. Several years later, when the husband dies, the current wife is astounded to find out that his ex-wife is getting the IRA of the 401k, and there's nothing that can be done about it. Matter of fact, there has been a landmark case of Kennedy versus the DuPont Retirement Savings Plan. I would write this down as well. The beneficiary form trumps everything, regardless of a will, a trust, a divorce decree, or any other signed document. The beneficiary form trumps everything, regardless of what a will, trust, divorce decree, or any other document says. Now, William Kennedy divorced his wife in 1994, and under the divorce decree, his ex-spouse waived her rights and any benefits from his retirement plan. Now, they agreed that their daughter would get Mr. Kennedy's 401k. Mr. Kennedy died in 2001. The 401k provider called the ex-wife to see what she wanted to do with the $400,000 in Mr. Kennedy's 401k. Guess what? She decided to keep the 401k money. Mr. Kennedy never removed his ex-wife as the beneficiary of his 401k. The daughter sued her mother, but lost the case. Now, if you want to avoid these types of mistakes, you'll want to take us up on our offer. Durable power of attorney. Durable power of attorney. A good estate plan clearly spells out the intended disposition of assets, or in other words, who gets what. It also names the beneficiary on beneficiary-driven accounts. Now, that includes transfer on death accounts. You may have heard of this before, and I would write that down, transfer on death accounts. You also could probably see it as TOD. So again, that's transfer on, it's a transfer on death designation, or TOD. And that's where you can keep control of your asset. This way you can ensure that when you're gone, your son, your daughter, or whoever will receive that asset. Now, let me mention something too about a power of attorney. I spoke with a gentleman last week, and his father had a health care power of attorney. It stated not to do CPR or to hook him up on life support. The father became ill, had to go to the hospital, and was hooked up to life support. No one could find the copy of the healthcare POA. Please make sure that one or more people will know where to find your important documents. Per capita versus per stirpes. This is something that people get really confused about. If you would, I would take a screenshot of this just to keep for your records. If you're like most people, you might not realize that there are different types of beneficiary designations when you're doing transfer on death in any type of beneficiary-driven account, like an IRA or 401k. So in this, you've got 3 children. Okay, the one child in the gray as deceased, and so for the per capita, the 2 living children split 50-50. Nothing goes to the deceased son's children at all. So that's per capita. Now, per stirpes is, in this case, you would still split the money up in thirds, with the 2 living children getting a third each, but the deceased child's son and daughter now share the other 1/3. Again, take a screenshot of that. Probate court. Now, the beauty about assets that transfer on your death to a beneficiary is that they avoid probate. Okay, they avoid probate. Now, what about the assets that don't transfer by beneficiary? How about the assets that transfer through your will? Okay, so for probate court, the purpose is to decide the legitimacy of a will. The process happens when assets are made public, claims are filed, and the judge decides on those claims. The usage is assets are passed via will or no will. And then, of course, you want to avoid probate because it can be expensive and it can often be lengthy. Remember Ron, the financial advisor that I mentioned early on that got killed in a car accident? Had he set himself up in such a way to avoid probate, his family could have saved over $1 million in legal fees and would not have had to wait 4 years to receive a distribution from his assets. Okay, let me go back here. Living trust. A living trust is used for assets that are not beneficiary driven. Write that down. A living trust is used for assets that are not beneficiary driven. A living trust and any trust in general is a tool that allows you to manage your assets from the grave. I'd write that down. A living trust and any trust in general is a tool that allows you to manage your assets from the grave. With a living trust, your assets are made private. So, a nosy neighbor down the street cannot find out what you had in assets after you die. So the reasons here again are: one, to manage the assets from the grave; two, you don't want your assets made public; three, to make the process easier on your heirs. Now, the pros for this are: one, you can change it if it's a revocable trust; two, you are your own trustee and you can name your own successor; three, it is harder to contest. What are the cons? Well, the cons are it doesn't save taxes and it is more complex to draw out and manage. This would be one as well that I would take a screenshot. One of the pros of a living trust is that it is revocable, meaning it is changeable. I just mentioned you can be your own trustee. This way, you still have 100% control of your assets while you live. However, the day that you die, that trust becomes irrevocable. Now, whether or not a living trust is right for you is one of the major reasons why people take us up on our offer. We can help you review your situation, your estate planning goals, to help you determine whether a simple will or trust can satisfy your estate plan. An example of where irrevocable trust might be advantageous would be if, in fact, your estate is over $12 million as a single person and over $24 million if you're married. By using an irrevocable trust, those assets grow between now and the day you die. All that growth will occur outside of your estate for estate purposes. Now, if you're concerned about what happens in case you need some type of nursing care, whether it's stay-at-home care or a nursing care facility, you might want to consider placing your assets into an irrevocable trust. That way, if you stay healthy for 5 years, then the state could end up picking up the tab for your nursing home care or even your full-time home health care. Now, that depends on your state. The drawback is there is no do-over on an irrevocable trust. The drawback is there is no do-over. So just keep that in mind. Durable power of attorney. Durable power of attorney. A while back, I had two clients. One was named Mark, the other one was named Peggy. And Mark handled the investments during their entire marriage. One day, Mark started to get a little forgetful, and then he was diagnosed with Alzheimer's. The onset occurred fairly quickly. He went downhill fairly quickly. He still, though, insisted on controlling a big portion of their investments, and he didn't want to give up control. Every time, his wife would try to talk to him about taking over control, he would get really paranoid about it. And as the situation continued to escalate, Peggy came to me with a concern. And of course, I asked her, I said, who's your attorney? And are there any legal documents that have been put together? I came to find out that they had a power of an attorney that was drawn up by a lawyer, which simply meant that all Peggy had to do was to go to the doctor, have a doctor sign off that Mark no longer has the mental capacity to manage their investments, and she legally has the right to take control of their financial affairs. Now, if she had not had that durable power of attorney, Mark could have squandered all of their money, and there would have been nothing she could have done about it. Advanced directive for health care. Have you had to make a difficult decision about a loved one, whether it's a grandparent, a parent, a spouse? Have you had to decide whether to keep someone on life support or not? And you weren't 100% sure you were making the right decision. Even worse would be if you know what that person's wishes were, and you shared those wishes with a doctor, for example, and the doctor comes back and says, I'm sorry, but I cannot do this for you because you do not have the appropriate documents. This is what happened in a case maybe 10 years ago with Terry Schiavo, and she did not have a directive for her health care or a living will. And as a result, in spite of her husband sharing what he knew to be her wishes, the doctors legally were not able to do that, and she stayed on life support for several years. These types of cases typically go to court. They get fought over, and lots of money is wasted. And at the end of the day, that person may or may not get his or her wishes. The basics of a good estate plan. At a bare minimum, you should have 4 current documents. This would be another good one to take a screenshot. A living trust, revocable or irrevocable, a durable power of attorney, a healthcare directive, and making sure that your beneficiaries are current. So, to summarize this, you should have a will and possibly a living trust. You should also make sure that your beneficiary designations on your beneficiary-driven assets are current and they represent the people to whom you want your assets to go to. You need a durable power of attorney to make financial decisions in case you're no longer able. You should also have an advanced health care directive and a living will so that you can designate someone to make medical decisions for you in case you become incapacitated. Now, more importantly is this: it needs to be done professionally. Please don't try this at home. Checking these 4 documents, getting a second opinion, making sure that the beneficiaries are current, making sure that your estate planning is for these reasons, or perhaps maybe the most important reasons that people who watch this webinar take us up on our offer. Okay, I want to congratulate you all for hanging in there with me. We are at the end of the webinar, so our offer is an estate planning analysis. An estate planning analysis. So who is this analysis for? Well, if you're not 100% sure that the accumulation and the protection of your assets from an investment standpoint is not as it should be, is not as it should be. If you're not 100% sure that the beneficiaries on your accounts or the beneficiaries in your will or trust are set up properly. If you're not 100% sure that the executors or trustees who are going to settle your estate are current. Now, advisors who normally charge around $1,200 for one of these consultations, and that is worth every penny of it. But tonight we are offering a complimentary analysis. All you have to do is schedule a call and not change the date or the time for that. This is our way of thanking you for watching this webinar. Now, let's get back to the offer here. I'm going to bring that back up one more time. And I'll pin this to the top of the chat as well. So you see the slide out there in green. It says schedule your call. You click on that green button. When you do, this is exactly the page that you'll be looking at. Click on a date that works best for you. Now, once you click on that date, this is the second page. Again, it looks just like this. The time slots are on the right-hand side. Click on a time that works best for you. And then finally, the third page, you enter your information. Please share with us why you would like to take advantage of the offer. This is very important because this will let us know exactly what you want to talk about. So this is very important. Please share with us why you want to take advantage of our offer. Now, don't forget to click on that blue button that says schedule event. Now, to make this call really worthwhile, you'll need to have several documents in front of you. Your IRA, 401k, TSP statements, any other legal documents as well will need to be in front of you during the call. Now, I know we've gone over a lot of information tonight, and you may have more questions. That would be another reason to take advantage of our offer. You know, some say knowledge is power. I believe that applied knowledge is power. You can either do something or do nothing. You can get prepared or you can get surprised. Here are other ways you can contact me and my team. You can see that there. We've got a link to the calendar, email address, phone number, and also our company website. I want to thank you for watching the webinar. I hope it answered a lot of your questions. If not, please feel free to send me an email. You can put questions in the chat box or the Q&A box. If you have any questions for me, I'll hang around for a few minutes. If not, take care and have a good night. Okay, let's see what questions we have. Okay, yeah, we've got a comment here about what long-term care costs will be in 15 years. Yeah, another one here says at least $150,000 per year in 15 years, 85,000. Okay. Yeah, I've got a question here about contacting a representative. Yes, you can do that. You can contact me to get information about that. Okay. This person wants to go back and look at what the four documents are. So let's go back and do that. And here they are. A living trust, a durable power of attorney, an advanced healthcare directive, and then also just make sure that your beneficiary documents have the current information on them. So again, that's living trust, durable power of attorney, advanced healthcare directive, and the beneficiary documents, making sure that that information is correct. The reason why we make this complimentary, and again, is for you taking the time to watch the webinar. Okay, looks like that's all the questions here. Let me check this one more time before we go. All right, that looks like that's it. Again, thank you for watching the webinar. Take care and have a good night.